Welcome to csstudents.com, a learning portal for company secretary students. Prohibition on the forward dealings under the Companies Act 2013. The Companies Act 2013 has introduced various new concepts and provisions in the Indian corporate laws. One of them is prohibition on forward dealings in the company's securities by certain persons. In this presentation, we would discuss the forward dealing transactions and the legal provisions prohibiting them. Section 194 of the Companies Act 2013 provides certain prohibitions on forward dealings. Broadly speaking, Section 194 prohibits any director or key managerial personnel from doing any forward dealings in their company's securities. For example, if Mr. X is a whole-time director in P Limited, by virtue of Section 194, Mr. X shall be barred to do any forward dealings in the securities of P Limited. Let's discuss the forward dealing transactions first. Then we would discuss the legal provisions. Forward dealing is a kind of contract wherein the price and the quantity is determined at the date of contract, but the consideration and delivery of security shall take place at a future date. For example, on 1st January, Mr. X enters into a contract with Mr. Y. As per the contract, on coming 31st of March, Mr. X will pay Rs 1000 to Mr. Y as consideration, and Mr. Y will deliver 100 shares of PQ Limited to Mr. X. In this contract, price and quantity were determined on 1st January itself, with a condition that the transaction shall take place on 31st of March. For a period between 1st January and 31st of March, Mr. X only holds a right to receive predetermined quantity of shares at a predetermined price, and Mr. Y holds a right to receive the consideration against the delivery of predetermined number of shares at a predetermined price. As per the agreement, the transaction would take place at a later date. It's a very basic example for forward dealing contract. Means, we execute the contract now. We give effect to the contract at a later date. During the interim period, parties only hold their right under the contract. Now we change the example a bit. Here everything is same, except there is no specific transaction date. But the agreement says, any time on or before coming 31st March by giving 2 days notice by Mr. X. The agreement also provides that, if Mr. X does not give notice to do transaction before 31st March, then the transaction will compulsorily take place on 31st of March, the last date of the tenure of the contract. Means, if on or before 31st March, if no communication is received from Mr. X, Mr. Y can tender the shares and force Mr. X to pay the consideration. In this contract, Mr. X has 2 rights. First, to determine the date of transaction, subject to an outer time of 31st March. And second, to receive delivery of shares at a predetermined price. Under the agreement, he has an obligation to purchase shares on or before March 31st. Mr. Y has one right, which is to receive the consideration on the date of transaction decided by Mr. X, and obligation to deliver shares if consideration is paid. But none of the parties have option to cancel the contract. Now, we make further changes in the agreement and insert an option. In our new example, Mr. X shall have an option to purchase 100 shares on or before 31st of March for a consideration of Rs 1000. When we say option to purchase, Mr. X may even decide not to purchase the shares at all. means the forward contract is giving him the liberty of not exercising his right to seek the delivery of shares at all. In this kind of agreement, Mr. X can either decide to purchase or not purchase. Mr. Y cannot compel Mr. X to purchase the shares. This is an example of call option agreement, because Mr. X has the option to call the delivery of shares from Mr. Y against the payment of consideration. But Mr. Y is having no option at all. In any event, during the tenure of contract, he has to accept the decision of Mr. X. For this purpose, the words right and option are synonyms for the legal interpretation purpose. Please note that the words right to receive the delivery are very important from the perspective of Section 194. In our previous example, option to call for delivery was with Mr. X, who was the buyer of the securities. Now, we slightly change the example. Under the new case, the option will be with the seller of securities. Means, now, under the contract, Mr. Y has an option either to give the delivery of shares or not to do the transaction at all. Therefore, on or before 31st March, Mr. Y shall have the right to tender the shares to Mr. X, with an option not to tender the shares at all. Under this contract, the liberty to do or not to do the transaction lies with Mr. Y, the seller. And, if shares are so tendered, Mr. X will have to pay the consideration and take the delivery. However, if no shares are tendered, Mr. X cannot force Mr. Y for the transaction, because, as per the contract, Mr. Y has the option, and not Mr. X. This is a simple example of a put option agreement, as Mr. Y has a right to put the shares to Mr. X to take the delivery against consideration. In terms of Section 194, we say that Mr. Y is having a right to make the delivery on or before the due date. The last example of forward dealings, wherein Mr. X has both the rights, right to ask the delivery, as well as right to make the delivery. In this scenario, either he can ask for the delivery against payment of consideration, or he can make the delivery against the receipt of the consideration. These forward contracts can also be done for debentures and other securities. We just discussed some examples of forward dealings of securities. As discussed earlier, Section 194 of the new Act clearly prohibits the directors and the key managerial personnel of any company to indulge into any forward dealings or forward contracts in the shares and debentures of their company. So, the directors and the key managerial personnel are definitely covered under the restrictive provisions. The prohibition is also applicable on the shares and debentures of the holding and the subsidiary companies. The prohibition also seems to be applicable on the securities of the associate companies, but, due to the conflicting language in the various parts of the section, there is a lack of clarity over associate companies. Let's see the example to have an easy understanding. If Mr. X is a whole-time director in PQ Limited, he shall be barred to do any forward dealings in the shares and debentures of PQ Limited, and shares and debentures of the holding company of PQ Limited, and shares and debentures of the subsidiary company of PQ Limited. The provisions also seems to cover the securities of associate company, but there is lack of clarity over that, which we would discuss later. Now we discuss the legal provisions. Subsection 1 of Section 194 says, no director of a company, or any of its key managerial personnel, shall buy, in the company, or, in its holding, subsidiary, or associate company. Clause A, a right to call for delivery, or, a right to make delivery, at a specified price, and within a specified time, of a specified number of relevant shares, or a specified amount of relevant debentures. So, under Clause A, the transaction is prohibited if it is proposed by any director or key managerial personnel. It has either a right to call a delivery or right to make a delivery. The delivery is going to be at a specified price. The delivery is going to be at a specified time. Delivery is going to be for specified number of relevant shares or relevant debentures. So, if any transaction satisfies all the conditions mentioned in the boxes, they are prohibited under Section 194 of the Act. Now, we discuss Clause B. Clause B says, a right, as he may elect, to call for delivery, or to make delivery, at a specified price, and within a specified time, of a specified number of relevant shares, or a specified amount of relevant debentures. So, the agreement, or arrangement, shall be prohibited under Clause B, if any director, or key managerial personnel, is having right to elect, whether to call a delivery, or make a delivery. The delivery is going to be at a specified price. The delivery is going to be at a specified time. Delivery is going to be for specified number of relevant shares or relevant debentures. The difference between Clause A and Clause B. There is a minor difference. In Clause A, the single transaction will provide for single option, which could be either the option to call the delivery or option to make the delivery. So, all the forward-dealing contracts with a single option shall be covered and prohibited under Clause A. However, Clause B shall cover and prohibit single transaction, giving both the options, with a right to elect, whether to call the delivery or make the delivery. Another important point. We need to understand that the law does not prohibit the director or key managerial personnel from buying or selling any shares of their company, or holding subsidiaries or associates. For spot delivery transactions, he can make the payment and acquire the securities anytime, subject to other laws. The prohibition is for buying any option or right to either take delivery or make delivery at a future date for a predetermined price and quantity. Or we say, it's basically the future contracts relating to the company's securities, which are barred under Section 194 for directors and key managerial personnel. The provisions of Section 194 use the term relevant shares or relevant debentures. Explanation in Section 194 defines the same. The explanation provides that, for the purposes of this section, relevant shares and relevant debentures mean shares and debentures of the company, in which the concerned person is a whole-time director or other key managerial personnel, or shares and debentures of its holding and subsidiary companies. So, in our earlier example, if Mr. X is whole-time director in PQ Limited, the following shall be relevant shares and relevant debentures for him, for the purpose of prohibition in forward dealings. Shares and debentures of PQ Limited. Shares and debentures of the holding company of PQ Limited. Shares and debentures of the subsidiary company of PQ Limited. However, if we carefully see the definition, the shares and debentures of associate companies are missing. We would discuss the anomaly now. Subsection 1 of Section 194 puts a restriction on the forward dealings in the securities of the associate companies also. But the shares and debentures of associate companies are missing from the definition of relevant shares or relevant debentures, which creates a confusion whether restriction on the forward dealings should also be applicable on the securities of the associate companies. Presently, there is no clear answer available to that. there is one more confusion with regard to the applicability over the non-executive directors. Although Section 194, subsection 1, prohibits all the directors and key managerial personnel from indulging into any forward dealings in the relevant shares or relevant debentures. But, as per their definition, the shares or debentures will not become relevant unless there is a relationship of whole-time director or key managerial personnel with the company. Therefore, should we understand for directors other than whole-time directors, the shares and debentures are not relevant. So far, there is no clear answer available for this issue also. But, provisions of subsection 1 provides the applicability on all the directors. So, it's safer to assume that all the directors are covered. Subsection 2 provides for the penalty for violation of Section 194. Means, if any director or key managerial personnel indulges into any forward dealings in any relevant shares or relevant debentures, he shall be punishable under subsection 2. The penalty is imprisonment for a term which may extend to 2 years, or a fine not less than 1 lakh rupees, but which may extend to 5 lakh rupees, or imprisonment and fine, both. We would also discuss subsection 3 of Section 194, which provides certain obligations and restrictions for shares and debentures acquired under any forward dealings in violation of Section 194. Subsection 3 of Section 194 provides that if any director or key managerial personnel acquires any securities in violation of subsection 1, he shall be liable to surrender the same to the company. Also, the company shall not register those shares or debentures in the name of the director or key managerial personnel after transfer. If shares or debentures are in demat form, the company shall inform the depository about the violation and ask them not to register the transfer of security. So, if there are physical securities, the company will not register the transfer. If securities are in demat form, depository will not record the transfer. Means, if there are violations of Section 194, the director or key managerial personnel will never be able to become the owner of the securities acquired under any forward contract. This is an additional penal provision under Section 194. So, in this presentation, we tried to touch upon the prohibition on forward dealings under the new Companies Act. After the enactment, this section has been in discussions in professional groups due to its conflicting provisions. Some people have also questioned the rationale of this section. From the first eye, it seems that these restrictions have been introduced to curb the insider trading. But Section 195 of the same Companies Act comprehensively covers the insider trading aspects. So, rationale of curbing the insider trading becomes questionable. Additionally, due to these restrictions, people will not be able to undertake the bona fide transactions which are otherwise required in the normal course of business. Also, Section 194 seems to be applicable on the securities of private companies. Therefore, the scope of the section becomes very wide and would also impact on private businesses where public at large is not involved. These are new provisions, thus, some clarifications or judicial interpretations would help to have more clarity. This is the end of the presentation. Viewers are welcome to post their comments and questions. Thank you for watching.